Imagine you're a CEO, right, sitting in a boardroom in Manila,
Okay, high stakes.
very high stakes,
No.
and you've just lost a $50 million dispute to like a competitor based in London.
Oh, wow.
Yeah, but here's the thing. A judge didn't rule against you. No jury actually heard your case.
Right.
Instead, it was just three private citizens sitting in a rented conference room in Geneva. They reviewed the contracts, and they made the call.
Yeah, it happens all the time.
Exactly. And yet, tomorrow morning, the Philippine government is going to force you to pay every single cent of that $50 million.
It's wild, isn't it?
It really is. So, welcome to the hidden parallel justice system of private arbitration.
It is a totally remarkable system. And, I mean, it's basically the absolute engine of the global economy.
Right.
Because we naturally think of state-run courts as, the ultimate inescapable authority.
The final word.
Exactly. But in the realm of international business, major corporations almost actively avoid those courts.
They don't want any part of it.
No, they don't. They draft contracts that specifically funnel their disputes into private arbitration. It creates this bespoke private legal universe.
And that parallel universe is exactly what we are exploring in today's deep dive.
Yes, we are.
We are working through this dense, but honestly incredibly revealing textbook chapter on the recognition and enforcement of awards.
Focusing specifically on the legal framework in the Philippines, right?
Looking at Republic Act 9285 and the Special Alternative Dispute Resolution, or ADR, rules.
Which is a lot of acronyms, but very important.
Oh, so many acronyms. But our mission today for you, the listener, is to figure out the actual mechanics of enforcement.
The real-world application.
Because it's one thing for, like, three private individuals in Switzerland to declare that a Philippine company owes $50 million.
Anyone can say that.
Exactly. It is an entirely different thing to actually extract that money across international borders. Okay, let's unpack this.
Let's do it.
How do these private closed-door decisions gain actual, like, teeth-bearing legal power in the real world?
Well, the mechanics of that transformation are really what make the whole system function.
Okay.
Because an arbitral award, which is the final decision rendered by that private panel of arbitrators, it's fundamentally just a piece of paper.
Right. It's just a contract outcome.
Exactly. It's the result of an agreement between two parties to let someone else decide their argument. But private arbitrators, they don't command a police force.
They can't arrest you.
No, they can't freeze a local bank account. They can't auction off a company's assets to satisfy a debt.
So they need the state.
Precisely. To do any of those things, you require the coercive power of the state.
Ah, I see.
And under the Philippine rules we're examining, that state power is accessed through the regional trial court.
The RTC.
Right, the RTC. It serves as the gateway. You bring your private award to the RTC, you file a petition for recognition, and if you're successful, the court essentially adopts that private decision.
And lends it the state's enforcement machinery.
Exactly.
So the RTC is basically border control.
That's a great way to look at it.
We're talking about friction, about crossing sovereign boundaries. Because, like, not all foreign arbitral awards get the same treatment when they show up at the RTC's doorstep, right?
No, they definitely don't.
They essentially carry different types of passports depending on where they came from.
Yeah, that is a very helpful way to visualize it. Because the legal texts distinguish heavily between what they call a convention award and a non-convention award.
Okay, what's the convention?
The convention in question is the New York Convention.
Ah.
It's this massive international treaty governing the recognition and enforcement of foreign arbitral awards.
Gotcha.
So if your private arbitration took place in a country that signed that treaty, your award is a convention award.
So it's got the good passport?
It's got the VIP passport. The process for getting the RTC to recognize it is highly streamlined.
Because the international community has basically pre-agreed to respect those outcomes.
Exactly.
But if you arbitrated in a country outside that treaty network, you have a non-convention award.
Right.
And you definitely don't get the fast lane.
It's no fast lane for you. The Philippine courts will still entertain a non-convention award, but they evaluate it based on comity and reciprocity.
Which sounds a bit more subjective.
It is. Comity isn't an automatic guarantee. It involves this diplomatic assessment. The Philippine court essentially asks, if the situation were reversed, would your country's legal system recognize a private award from the Philippines?
Oh, interesting. It's like I'll scratch your back if you scratch mine.
Basically, yeah. And if the answer is yes, the RTC is likely to recognize it, following Supreme Court procedural rules, just to maintain reciprocal legal harmony.
Okay, here is where the mechanics get truly fascinating to me, because it centers on this absolute requirement for local integration.
The translation requirement.
Yes.
Yeah.
When you arrive at the RTC seeking enforcement, you can't just hand the judge a towering stack of foreign legal documents and demand your money.
No, they won't accept that.
You are required to submit the original award, or a highly authenticated copy, along with the original arbitration agreement. But if those original documents are not in an official language of the Philippines, the enforcing party is legally mandated to provide a duly certified translation into an official language.
Which is a huge deal.
It is. And practically speaking, this means translating complex international commercial legalese into English, or, crucially, into Tagalog.
Yes. What's fascinating here is the strictness of that translation requirement.
It's not optional.
Not at all. It is not a suggestion. It is a jurisdictional prerequisite. You absolutely cannot bypass it, regardless of the size of the award.
I just find the visual of this so compelling.
How so?
Well, you might have this massive, intimidating legal judgment drafted by, like, arbitrators in Zurich,
Right.
written entirely in German or French,
Yeah.
detailing the absolute nuances of a multinational supply chain.
Oh, sure. Very dense stuff.
But to unleash its power within the borders of the Philippines, it must be painstakingly translated and certified into Tagalog.
Yep.
It's like trying to use a foreign gift card, you know?
Oh, that's a good analogy.
Like, the card holds real value, maybe hundreds of millions of dollars, but you cannot actually spend it until it is converted into the local currency.
And validated by the local system.
Exactly. The Tagalog translation is that conversion process. It forces this abstract, stateless international agreement to ground itself in the cultural and legal reality of the local sovereignty.
It really anchors the international to the domestic. And that anchoring leads to a profound legal transformation the moment the RTC actually confirms the foreign award.
It changes forms.
Completely. The source material is very explicit about this. A foreign arbitral award, once confirmed by the RTC, is no longer treated as a foreign entity.
Really?
Yeah. It is not even enforced as a judgment of a foreign court. It is enforced in the exact same manner as a final executory decision of a Philippine court of law.
Wow. So it entirely sheds its identity.
It does.
It ceases to be a Swiss or British decision and becomes, for all practical enforcement purposes, a Philippine decision.
The state fully absorbs it. It adopts the private contract dispute resolution as its own sovereign command.
That is intense.
It illustrates just how heavily the legal system prioritizes the finality and efficiency of arbitration.
But, I mean, the RTC cannot just be a rubber stamp, right?
Well,
Because if the RTC is the gateway, what happens when someone tries to slam the gate shut? If I'm the CEO staring down a massive company-ruining payout, I am going to deploy every lawyer I have to keep that award from being recognized.
of course you would. And the rules absolutely provide mechanisms for refusal, but they are deliberately narrow.
Narrow.
When we move from enforcement to the grounds for refusal, specifically for those streamlined convention awards, the vital thing to understand is the burden of proof.
Who holds it?
It rests entirely on the party fighting the enforcement. The court begins with the presumption that the award is valid.
And you have to prove otherwise.
Exactly.
And the text outlines very specific scenarios where you can actually fight it.
Yes, very specific.
Like, you can challenge it if the parties lack the legal capacity to sign the arbitration agreement in the first place.
Right.
Or if the losing party wasn't given proper notice of the proceedings.
That's a big one.
You can also fight it if the award dictates matters completely outside the scope of what the contract actually said they would arbitrate.
Right, if they overstepped.
Or if the tribunal's composition violated the agreement. Say, you contracted for a panel of 3 arbitrators and only 2 made the decision.
Yes. But notice what all those grounds have in common.
What's that?
They are entirely procedural.
Wow.
They focus exclusively on the fairness of the process. The RTC is not an appellate court for the arbitration.
They aren't retrying the case.
No. If you claim you weren't given proper notice, the RTC will look at the timelines, the emails, the mailing receipts to see if procedural rules were followed.
Right.
What the RTC will not do is reevaluate the core evidence or call witnesses back to the stand or decide if the arbitrators made a mistake in their legal reasoning.
They don't care about the actual business dispute at that point.
They only check if the fundamental rules of the game were respected.
Okay, but let's look at the final two grounds for refusal. Because these are determined by the RTC itself, even if the losing party forgets to bring them up.
Yes, these are important.
The RTC can refuse enforcement if the subject matter isn't capable of being arbitrated under Philippine law, or, and this is the massive one, if the recognition or enforcement would be contrary to the public policy of the Philippines.
The public policy exception?
Wait, public policy sounds like a giant subjective loophole.
It does sound like one, doesn't it?
Yeah. Can a losing party just walk into the RTC and claim, Your Honor, paying this $50 million penalty to a foreign competitor will bankrupt a local employer, which is terrible public policy?
It is very easy to misinterpret that clause, but I want to encourage some critical thinking here because judicial history shows the threshold for violating public policy is astronomically high.
So you can't just use it to save jobs.
No, public policy does not mean this outcome is economically disadvantageous for a local entity. It refers to the absolute most foundational moral and legal principles of the state. To trigger this exception, enforcing the award would have to compel an action that is deeply illegal, corrupt, or fundamentally offensive to the core values of the nation.
So if the underlying contract that went to arbitration was actually an agreement to, like, smuggle narcotics or traffic human beings?
Exactly that. A standard bruising commercial dispute over a breached construction contract or a failed merger will never trigger the public policy exception.
No matter how much financial devastation it causes the losing party.
Exactly. Furthermore, the rules build in a really powerful safeguard against parties throwing up these refusal grounds simply to buy time.
Oh, really? What's the safeguard?
If a party applies to reject or suspend the enforcement of the award, the RTC has the authority to order that complaining party to provide appropriate security.
Ah, so you can't just file a flimsy objection about proper notice to delay the payout by 6 months.
Nope.
The judge can look at your objection and say, sure, we will hear your argument, but first, you need to place the $50 million in escrow.
It entirely strips away the incentive to use the court system as a stalling tactic. If you want to fight, you must secure the funds first.
Put your money where your mouth is.
Exactly.
So let's follow that thread. Let's say the RTC recognizes the award, they stamp it, it is now a local judgment, and you, the losing party, still want to fight it.
You're very persistent.
Yes. The sources note that you can appeal the RTC's decision to the Court of Appeals, following standard Supreme Court procedural rules.
You can.
But this leads to what might be the most jaw-dropping detail in the entire textbook chapter.
It's a big one.
If you want to appeal the RTC's decision to recognize the award, the Court of Appeals requires you to post a counterbond.
Yes.
And that counterbond must be equal to the entire amount of the award.
The full, complete amount of the judgment.
I liken this to a high-stakes poker game.
Oh, totally.
Imagine you've just lost a massive hand. You are convinced the dealer made a procedural mistake, and you want to challenge the outcome with the casino's pit boss.
Right.
But the casino tells you, sure, we will launch an investigation into the dealer, but to even start that process, you have to place an amount equal to the entire pot back on the table.
Yeah.
That is an astronomical barrier to entry.
It is, but the barrier is massive by design.
Why?
Well, if we step back and look at the whole architecture of arbitration, it exists to be an alternative to endless grinding litigation.
Right.
The primary selling points are efficiency and finality. If corporations could simply drag arbitral awards through the regular appellate court system for a decade, the entire purpose of the private system collapses.
It defeats the point.
Exactly. The counterbond rule exists specifically to deter those frivolous delay tactic appeals.
It forces the legal team to have a very sobering conversation with the CEO.
Are we sure about this?
Yeah, like, are we truly fundamentally certain the RTC made a verifiable legal error in recognizing this award? Or are we just furious that we lost the arbitration?
Right.
Because risking another $50 million in a counterbond is terrifying.
And the system actively protects that finality. The rules even state that if the parties explicitly stipulate in their original contract that any arbitral award shall be final and unappealable, that waiver is entirely valid and enforceable in the Philippines.
Wow.
You can prospectively sign away your right to an appeal years before a dispute even arises.
But is there absolutely no safety net? What if the private tribunal goes completely rogue?
There is an emergency hatch, but it is incredibly narrow.
Okay, what is it?
The implementing rules state that even if you sign a waiver of appeal, you retain the right to seek judicial review via a special petition for certiorari under Rule 65 of the Rules of Court.
Okay, let's clarify certiorari, because that just sounds like another word for an appeal.
It is fundamentally different.
How so?
Think of it this way. An appeal is arguing that the referee made a bad call on the field, that they misinterpreted a rule or missed a foul.
Okay.
A petition for certiorari, specifically citing grave abuse of discretion amounting to lack of jurisdiction, is arguing that the referee took a bribe, walked onto the field, and started playing for the other team.
Oh.
Yeah, it is an attack on their fundamental authority to even make a decision, not an argument over the merits of the decision itself.
That makes perfect sense. Okay, so we know how strictly these awards are enforced and how punishing it is to appeal them.
Very punishing.
But let's look at the actual proceedings. Who is in the room making these decisions and who is footing the bill?
This is where it gets really interesting.
Because the rules governing the arbitration room itself are wild. Let's talk about legal representation.
Okay.
In international commercial arbitration conducted in the Philippines, a party can be represented by anyone of their choice.
Anyone.
They do not have to be a lawyer admitted to the Philippine bar unless they also need to appear in a local court outside the arbitration.
Right, the parties maintain total autonomy over who speaks for them.
Wait, I have to push back on this.
Why?
Allowing a non-lawyer to represent a megacorporation seems incredibly reckless. Like if I'm a CEO arguing a billion-dollar tech patent case, why on earth would I want like a software developer leading my strategy instead of a seasoned, aggressive litigator?
Because arbitration is a creature of contract, not a creature of statutory law.
Okay.
In a traditional court, you need a seasoned litigator because navigating the labyrinth of civil procedure, rules of evidence, and judicial precedent, that's half the battle.
True.
But in arbitration, the rules are largely whatever the parties agreed they would be.
Oh, I see.
So in a highly specialized tech patent dispute, a brilliant software developer who intimately understands the architecture of the code might actually be infinitely more effective at persuading a panel of tech-focused arbitrators.
Than a lawyer who doesn't even understand the underlying technology.
Exactly. Technical expertise frequently outweighs procedural legal knowledge in these specific rooms.
That reframes it completely, and that autonomy extends to the privacy of the room, too.
Very much so.
The text stresses that proceedings, records, evidence, and the award itself are strictly confidential.
Yes.
The phrasing used is that they shall not be poolside reading.
I love that phrase.
Right. They cannot be published without the consent of the parties or a very specific limited court allowance.
Contrast that with a regular court case. When two massive competitors sue each other in public court, journalists can pull the filings.
Anyone can see it.
Rival companies can sit in the gallery and listen as trade secrets, financial vulnerabilities, internal emails. All of it is spilled in public testimony.
It's a bloodbath.
It is. Arbitration, on the other hand, functions as a legally protected black box.
And it is a relentlessly forward-moving black box.
How do you mean?
Well, the text notes that the arbitration process does not even stop if one of the parties dies. If someone initiates an arbitration and then passes away, the proceedings don't reset. The tribunal simply substitutes the deceased with the executor or administrator, and the case just continues.
The dispute outlives the disputants.
That's crazy.
But maintaining this level of bespoke, highly specialized secretive justice requires significant capital.
I bet.
The financial realities are stark. Under Article 4.46 in the sources, the arbitral tribunal itself fixes the costs of the arbitration.
Okay.
And this is not a standardized $200 court filing fee.
What are we talking about then?
The term costs encompasses the professional fees of the arbitrators, which scale based on the dispute's complexity and the amount of money at stake.
Right.
It includes their travel expenses, the cost of any technical expert advice the tribunal required, witness expenses.
And what about the lawyers? Because top-tier representation isn't cheap either.
The tribunal can absolutely include legal fees in the final cost assessment. Yeah. If the winning party requests reimbursement for their legal representation, the tribunal can order it, provided they deem the amount fair.
If it pays.
The fundamental default rule is that the losing party foots the entire bill.
Ouch.
The tribunal retains the discretion to apportion costs if the circumstances demand it, but the general expectation is a winner-take-all scenario regarding expenses.
The stakes are astronomical.
They really are.
You aren't just paying the $50 million award. You're paying the private judges, The structural engineers they brought in as experts, the luxury hotel conference room rentals, and the opposing side's legal team.
Yes.
And the tribunal can demand supplementary deposit from both parties while the arbitration is actively ongoing, just to ensure the money is there.
They want to make sure they get paid.
If you fail to pay your deposit within 30 days, they can suspend or outright terminate the proceedings. It is fiercely pay-to-play.
It is a private service, and the service providers ensure they are compensated before they issue their product.
Okay, so we have spent a lot of time discussing international borders and bringing foreign awards into the Philippines.
We have.
But let's look at disputes that never leave the country. You would think domestic arbitration would be simpler, but the state actually applies a completely different layer of scrutiny to disputes between its own citizens.
It does. Domestic arbitration operates under its own distinct framework.
Which is?
Primarily, Republic Act 876, the arbitration law, along with specific articles of the model law.
Right.
And the state creates highly specialized carve-outs. The most prominent example is construction disputes.
Construction.
Yeah, they do not go through standard domestic arbitration. They are governed by Executive Order 1008 and are routed exclusively to the Construction Industry Arbitration Commission.
Why construction specifically? Why does building a skyscraper get its own entirely separate legal commission?
Think about the physical reality of a major construction site.
Okay.
You have hundreds of workers, heavy machinery rented by the hour, and tightly sequenced supply chains.
It's chaos.
Organized chaos. But if a dispute arises over, say, the quality of the concrete poured on the 10th floor, you cannot halt the project and wait 5 years for a standard court docket to resolve the issue.
No, the delays would bankrupt everyone involved.
Exactly. You need an arbitrator who can literally put on a hard hat, walk the site, read the architectural blueprints, and issue a binding decision in a matter of days so the work can continue.
That makes a lot of sense.
Standard judges are simply ill-equipped for that level of technical, delay-sensitive dispute resolution.
Right, the law has to adapt to the speed of the industry.
Precisely.
The text also highlights a specific rule regarding vulnerable parties in domestic arbitration.
This is an important distinction.
Yeah, a domestic controversy cannot be arbitrated if one of the parties is a minor or someone who has been judicially declared incompetent.
Unless a court having jurisdiction specifically approves a petition by their legal guardian.
So why the extra hurdle?
This is one of the rare instances where the state intervenes in the freedom of contract. The state recognizes that arbitration can be a ruinously expensive, complex, and unappealable process.
Right, we just talked about that.
So it strips away the normal protections of the public court system. Because of that, a judge must verify that a vulnerable person is not being taken advantage of before they are locked into that private room.
So what does this all mean for the parties who actually are in the room?
Well, there are rules for them, too.
Yeah, the domestic rules contain a powerful principle regarding how you conduct yourself during the arbitration.
The non-mandatory rules.
Yes.
Yeah.
If a rule is non-mandatory, meaning it's a procedural guideline, the parties could have mutually agreed to ignore.
Right.
And you notice that rule is being broken by the tribunal, you have an obligation to speak up immediately.
You can't just sit on it.
If you know about the non-compliance and you simply proceed with the arbitration without stating your objection right away, you legally waive your right to complain about it later.
It prevents a deeply cynical legal strategy. You cannot spot a procedural error, stay quiet, keep that objection in your back pocket, wait to see if the final award goes your way, and then only pull out the objection to invalidate the award if you lose.
Oh, that's clever.
It is, but the system demands active participation and good faith from the parties. You must resolve procedural issues in the moment.
It is the ultimate legal application of speak now or forever hold your peace.
Exactly.
Let's take a step back and look at the massive system we've just explored.
That's a lot to take in.
It really is. Arbitration is not just an informal handshake agreement or like a gentleman's club for resolving minor squabbles.
Far from it.
It is a rigorously structured, legally binding, alternate universe of justice. It operates with eye-watering financial stakes, strict confidentiality that completely locks the public out, and procedural rules that heavily financially penalize anyone attempting to appeal a loss.
It's a very rigid system.
And yet, this private universe remains inextricably tethered to the power of the state. It relies entirely on the regional trial court to give it actual force.
It needs that gateway.
And it navigates those mandatory translation rules, like that fascinating Tagalog requirement we discussed, to ensure the state truly comprehends the foreign mandates it is enforcing. It's just an intricate, high-stakes dance between private corporate agreements and local sovereign power.
It is a remarkable mechanism, and analyzing it at this depth, it raises an important question about the long-term consequences of this system.
Oh, where does this lead us?
Well, think about it. Our public justice system relies on case law.
Right.
When a novel dispute over a new technology or a new type of financial fraud goes through the public courts, the judge writes a decision that sets a precedent.
Which helps everyone else.
Right, that precedent updates the law and helps everyone navigate the future. But if massive corporations are increasingly routing all their most complex, cutting-edge disputes into the confidential black box of private arbitration, those decisions are entirely secret.
Nobody sees them.
They set no public precedent. It makes you wonder, as more and more of the global economy shifts into private arbitration, are we slowly starving our public justice system of the very cases it needs to evolve our laws for the future?
That is a phenomenal point. The law can't adapt to the future if the future is being debated in secret.
Exactly.
A truly provocative thought for you to ponder the next time you read a headline about a massive corporate dispute being quietly settled out of court. Thanks for joining us on this deep dive. We will see you next time.